Welcome to INN's Student. INN Student is a platform for law students to come here and deliver a lecture on the topic of their choice. Today we have with us law student Sakshi Deepak Wagh. She is going to speak on ex-parte decree in Civil Procedure Code. She is from Subhash Desai College of Law. So without wasting further time, I would request Sakshi to commence with her lecture. Thank you.
Good morning everyone. Myself Sakshi Deepak Wagh from Subhash Desai College of Law. Today I am going to talk about a very important topic in civil law, that is ex-parte decree under CPC. So let's begin with the topic. You must have heard the fundamental principle of natural justice, which is audi ultra partem. This is a Latin phrase in which it means heard the other side. In simple Hindi language, it means दोनों तरफ की बातें सुननी चाहिए. What this means is, before making any decision by the court has to give chance to both the parties to present their case to the court. This principle delivers this right to the parties. Now you must ask a question. What if one of the party does not appear before the court? क्या होगा अगर एक पार्टी कोर्ट में आई ही नहीं? So here comes the concept of ex parte decree under CPC. What is ex parte decree? An ex parte decree is a decree or a decision passed by the court when one of the party, usually the plaintiff, is present. Means सिर्फ plaintiff present होगा और defendant present नहीं होगा. For example, suppose a person has filed a suit against a person B. Then a person serves the summons to person B, but due to some reasons defendant B does not appear to the court. So the court has the power to pass ex parte decree under CPC, and the proceedings will be go on within the matter. When is an ex parte decree passed? Under Order 9, Rule 6 of CPC, the court may proceed to try the case ex parte and pass an ex parte decree in the same if one of the fixed date in summons for the defendant to appear and answer the plaints the defendant is not present. It is provided that the summons was duly served in sufficient time to enable the defendant to appear and answer. Also, in Order 8, Rule 10, the CPC states that the defendant shall submit its written statement within 30 days from the date of receiving summons. This time period of 30 days can be extended by the court not more than 90 days. If the defendant fails to submit the written statement in such period, then the court under Rule 10, Order 8 has the directions to pass ex parte decree. Now, the ex parte decree has been passed by the court, but what if the defendant is not appeared because of genuine reasons, like he is ill or he has gone out of or he has not received the summons? Then the defendant has the remedies available with him to set aside the ex parte decree. So defendant has remedies under Order 9, Rule 13 of CPC to set aside the ex parte decree passed against the defendant. Also, the defendant can file an appeal under Section 96, subsection 2 of the code, and also file a review petition under Section 114 of the code. So, key takes: ex parte decree is a decision made in absentia of one party, but not after proper procedure. The principle of audi ultra partem ensures justice by giving everyone a fair chance to be heard. Code provides remedies to set aside ex-parte decree to protect fairness. Remember, when you hear ex-parte decree, think of it as an exception to the rule of hearing both the parties, but with safeguarding to protection fairness. The law also always tried to balance speed and fairness because कानून सबके साथ न्याय करता है. Thank you.
Sakshi, thank you very much for giving a nice overview of the concept of ex parte decree in the Civil Procedure Code, because this is a very important aspect. Lot of people feel ke अरे यार बिना सुने क्यों दिया, but as you rightly said, it is an exception and it is not a regular rule. So thank you very much. A small token from Hammurabi to you.